person, a permit specialist, some human contact, similar to some of the services that our district coordinators in Active 50 give, but that would be broader in terms of being able to help either with municipal appeals and or A&R as well as Active 50. So I really want to just open up the floor for a discussion about this, what people see in terms of the needs, and what makes sense. Megan?
Megan with the Vermont Chamber. ACCD used to have this position. Kurt Carter, who's now with the Greater Burlington Industrial Corporation, used to serve as the permit ombudsman for ACCD, and by all accounts was incredibly helpful. Now, this was, I should qualify this, that he was with the Department of Economic Development and worked mostly on the industrial commercial development side of things. But I do think that is the appropriate place outside of the body that is making decisions, whether it's the commission and the coordinator or appeals, having that permitting ombudsman be in a friendly, non-involved agency like ACCD. So whether it's, and Kurt would help with all of the permitting and understood the world of permitting, whether it was A&R or Act 250 or municipal, and could bring, had, you know, was sort of liaison for all the different departments to bring people together in conversations. So I could see that being a role both in Department of Economic Development and in housing in terms of the folks who are there to help the applicants. I don't know where you would put that ombudsman for the public, but for the applicants, I think having positions like those in the Agency of Commerce that houses economic development and that houses the Department of Housing would be the appropriate place for those types of positions to live.
And they would be able to help with municipal Act 250 and the A&R.
Yeah.
So the whole shebang.
Yeah, so that was, I mean, that was what he did. He just knew permitting inside and out for the state. And if he, you know, if someone came to him or had a concern about something they were hearing, he also had, you know, higher level relationships that he could go to the secretary or the appropriate commissioner in A&R and have conversation.
And what about assistance for either municipalities as parties to these appeals, or for neighbors or other folks, primarily the pro se folks that, you know, there is a criticism that slows down the process. And so trying to equip them better to participate more efficiently. Is that a function that we see could be shared, whether it's someone helping a permittee or an applicant, as well as someone to assist for the general public or an entity that would not be the permittee, maybe an governmental entity?
When you have regional planning commissions, you know, that are sort of designed to support municipal, you know, kind of municipal planning. I don't know if they'd be the right place, but.
We have Annette online. She has her hand up.
Yeah, I served on the Rutland Regional Planning Commission for about a dozen years, and I don't see that there's a role to play there. But there are in other states, they have different names, and some of them are housed in the Attorney General's office. Some states do have independent offices, Consumer Affairs, Consumer Advocate. I've seen some very effective work coming out of Connecticut and Illinois, Pennsylvania. They cover, they can be specific to, for instance, utilities, but they can be more general. And I can see in Vermont that we could have as if we could figure out how to establish it, an independent office that covered the whole range of, um, I'm not sure what the right words are, but being an advocate, I mean, we have in the Department of Public Service the public advocate, but the public advocate doesn't really do that I have found myself now in the role of assisting municipalities, assisting citizens, explaining the PUC process over and over and over again in a way that somebody in the state level really ought to be doing this. So it's sort of what district commission or district coordinators do at the district coordinator level. But having participated in these different stakeholder processes, I see there is a need for the citizens, the permittees, how to navigate these various processes, someone to coordinate it all. And there are a variety of issues. And I think also this environmental justice law plays into it because that's cross-cutting across all sectors. And there have been meetings that all the different state agency people have had to attend. So I like the idea. I'd like this group to think broadly about what it could look like, because it could be very effective in making the process more efficient. Thanks.
Thank you, Catherine.
Thanks for taking my hand raised the old-fashioned way. Teams won't let me raise my hand. I wanted to offer a couple of thoughts. One is that I think the A&R permit specialist model remains a good model. That is something that was accessible, understandable, and is a model that I think could be replicated and serve in different functions. And secondly, I do think that there is a role for the regional planning commissions in terms of the municipal assistance. We have different levels of capacity to serve in that role, depending upon the resources and the expertise of staff. And if that is a role that there's consensus should be expanded, I think it could benefit from some statutory definition in our duties. Thanks.
Thank you, Catherine. Do you have any specifics when you say that we should replicate the A&R permit specialist position? Last meeting, I had Pete Kofska with us because he's one of our district coordinators, but he also actually had worked that position at A&R before it was eliminated. Is there any particular aspects of it that you want us to know about? We'll get more information on this, but that you feel is important to replicate of that job duties and the services?
Yeah, I would say there are a couple of things that would be important to replicate. One is when they used to travel around, even when they had larger geography, and be available like every Tuesday morning at the Regional Planning Commission office, people would know they could come in similar to a zoning administrator at a local office. They permit specialists that we worked with were always very knowledgeable from a broad base of permits. And although they had a form that they checked off, they did more than just check off the form. They actually had the knowledge to talk through potential issues with applicants so that they could be identified early on. And it was a really great opportunity for local officials to actually refer people to the state permit process as well, because local officials are often the entry point for inexperienced builders, developers who aren't familiar with the state permit process. So accessibility, knowledge, I think would be two important things, a broad knowledge.
And in terms of the actual tasks that they're doing, you're saying more than a traffic cop, kind of plugging them into the resources that they need?
Yeah, I think that one of the drawbacks of the permit specialists, in my experience as it existed before, is they didn't necessarily have the power of contact to like get to the bottom of an issue that a person might be having, and expanding the role to help in that aspect, I think could be really good.
Great, thank you. That's great information. Who else has information they'd want to share on the permit specialist ombuds office? I think we have Jeff Hand coming in. Now, how about, I don't want to get to, I have not asked this question before, and we can certainly backtrack and go over any other issues that people would like to have more conversation about. But I also want to open up the window for people to be able to talk about other ideas that we have not touched on, whether they be within the environmental division, the way that we have things now in our status quo. What other ideas do we have? Is there anything within the Act 250 permitting and processing of appeals that we can look at to try to improve? Like to open up the door for people to bring forth anything that we haven't heard yet, or ideas that you've been thinking about that you might want to discuss. Let me ask you this, unless someone raises their hand and wants to start talking, I'm going to throw out an idea. So whether we're talking about appeals from a municipality or an appeal from, say, the district commission, it sounds like we've heard a lot of information about the concerns about on the record and what de novo review provides. But I have a question, because this issue came up and there was a concern by folks that that if you do a de novo appeal, say from a town zoning permit, you are losing any voice that the town has on a de novo appeal. You're throwing it out the window and starting fresh, a blank slate. And the question that I want to ask is, so in our current situation, the town gets to go to the environmental division and be a party if they wish. They don't have to, but they're allowed to go and become one of the litigants in the case that their DRB decided, which is unusual. If you were in the court system and a lower court made a decision and it got appealed, that court doesn't go up on a de novo appeal and argue why the higher tribunal should decide the same way that they did. So in that sense, it's a little unusual. But the question that I have is there a way, is that a problem having the municipality involved in the appeal? And on a de novo appeal, is there a different way that we can give voice to the municipality besides, just a judge or a board applying a zoning ordinance that is created in that town to a particular set of facts? What I'm getting at is, if you look at the Public Utility Commission, municipalities can be parties, but they can also be given the opportunity to express their opinion and make a recommendation. So, for example, if they're, they get to weigh in on, gee, is this project in compliance with our town plan? And they get due consideration, the commission will listen to it. Or if they have an enhanced energy plan, and this is a siting for a renewable energy project, they would get substantial deference. The PUC will listen to the municipality. Is that the kind of mechanism in any way that would be beneficial? Do we like that? Do towns like to be a party? Or is it a drain on their resources, where they should have some option and opportunity to express their opinion without having to actually become part of the litigation? Elizabeth.
So you described the town's role versus the lower court's role, and it strikes me that they're totally different context because the town actually created the zoning through a public process, expressing the wishes of the people that live there and what their intentions are around certain areas of town. So just in terms of like how you said it's unusual because the lower courts don't become a party to a higher court case. It does seem like it's a different situation because the townspeople are so involved in defining the landscape of whatever's getting decided. So just on that point, I think it is different. And I don't have a comment on the other question you asked, because I'm not sure I feel about it, but I hear it.
Sure. Does anyone else, or, this is a crazy curveball that broke through. It was mentioned to me when we were having the discussion about on the record versus de novo. And town's kind of feeling shut out, but then it was expressed to me, but we don't want to spend money on the lawyer to go and monitor the case, kind of idea. So I thought I would throw it out there. Megan?
Megan Vermont Chamber, isn't the town's role in like their municipal zoning, and it seems like the town has an extensive amount of control about what happens in their community with all these other levers. Act 250 is the state regulation. I guess I'm struggling with why the town should have additional say in the state
Oh, I was
regulatory framework.
right. No, I was, my thoughts went to the notion of on a de novo appeal, you're basically throwing out what the town said about how their zoning ordinance should be interpreted and applied in a particular case. And so I was trying to explore whether there was a different way if you did it in a de novo appeal.
On a municipal?
On a municipal.
Okay, sorry, that was my confusion.
Oh, I'm sorry.
I was on Act 250.
I'm sorry if I mixed the two. I was just trying to address the concern about, or de novo, on de novo, it doesn't matter what we said, and we have to go and fight for the way that we want our ordinance interpreted. That's the issue that I'm trying to see if there's a relief for towns that don't want to spend the resources, but still want to have a voice in the de novo environment. That's what I was trying to see if that was a concern that we should look at and address.
So I don't have a ton of experience, but in our one case that was pretty intense, the fact that it was de novo, because it was such a heated situation, was very validating for the town because they were sort of hands off at that point, and the court ruled, and then the Supreme Court ruled, and it was very consistent all the way down the line. So some of the local narrative that was happening in town was directed at some of the members of the Development Review Board and questioning their decision making, and so it was actually quite a positive thing for, I think, those members to see that their decisions were validated at two layers of the court system. So in some ways, they did have a voice, even though they were a passive participant at that point, they still were very much validated. And I think it made a big difference in a very small town where it got kind of ugly because they were validated and that they did the right thing. They interpreted the zoning correctly and it sort of passed the test at two layers of the court system.
Anything else? Yeah. The other thing I'd like for folks to jump, I'm sorry, somebody, Annette?
So in that case, if there was an appeal by neighbors, who was on the other side if the town was playing a passive role?
Developer, and that was us.
Oh, okay, I got it. Thanks.
The next discussion that I think is important that we've heard several times now. We have heard about how the administrative law process the APA, if you will, where an executive branch board can act in a quasi judicial manner. And we've heard, gee, we might be able to do it faster. And we've had questions about deadlines, and we've heard about discovery and motion practice. And I was wondering if the lawyers that are here or others can explain how is it that we can speed things up in the administrative procedures atmosphere versus being in the court system under the civil rules of procedure. And I'm going to throw it out. Anybody wants to jump in and explain how is it that we can control better the timing? Besides having more than 2 decision makers. Anyone want to take a stab at how discovery could be different? And what exactly is discovery and how does it work? So, okay, John.
I mean, you sort of, helped answer this question, or earlier hearing, but I mean, my understanding is that it's just the practice in administrative hearings to have limits on discovery. I think you mentioned already, like, the POC, like time, that you have to basically, it's quick turnaround times. I think having rules about cumulative and duplicative discovery, making it clear up front that the hearing officer is not, that's the rule. The rule is not to just keep layering on more and more discovery. Having it so that initial round, you should be able to get what you need, and you have a burden to prove like why you needed more, like shift the burden. And under the civil rules, this kind of just goes on, it keeps going on, that mechanism isn't built into it. You could go to the court and ask for a protective order or some relief from discovery because of those things, but the general practice seems to me to be, it just keeps going unless somebody complains about it, rather than having rules that says we're gonna have strict time limits, we're gonna have, everyone's entitled to a round of interrogatories, questions. So discovery is just, for non-lawyers who don't know, it's just the process of, at the beginning of the case, gathering information about the case through mechanisms like filing questions that the other side has to ask. It could be depositions. You could have a rule that says depositions, have to be approved, by the court, that they're allowed, but you have to make some sort of showing that they're necessary, that it's a big expert witness case, so you need depositions but just things like that to sort of shift the burden and the expectation and the rules that we're gonna be tight about this and there are gonna be limits. We wanna make sure people get the information they need to basically have due process in processing the case. But upfront, the expectation is that, there are gonna be limits and you can write those into the statute or to the rules. So no, that's been, how I've seen it work, and we can then talk about what the specific rules should say. And there are different models out there, I think, but.
So then in terms of this deadlines and timelines, I know the FCC with telecom, for example, federally, there was, a shot clock of 150 days processing of applications. I think our statute in Vermont and with the PUC for telecom is 180 days. But it's not a deemed approved situation. So, John or others, can you explain in terms of, I know we have disposition guidelines that are goals for the environmental division. How is it that in the administrative law setting, we can have timelines that are more enforceable?
While they're thinking about that, can I just jump in and quickly say, so, in the court setting currently, just to make sure, I know the lawyers will know this, but, so this, for the discovery process, which is the exchange of information between the parties prior to the hearing. There is a Rule 2 of the Vermont Environmental Court Proceedings Rules that Rule 2C is about discovery, and it says, unless the parties otherwise agree, the court in a pretrial order shall establish the type, sequence, and amount of discovery available under rules. Under the rules of civil procedure, limiting the discovery permitted to that which is necessary for a full and fair determination of the proceeding. And in practice, what happens is when you go to the pretrial conference, often the party that's taking the appeal will have a proposal for what the schedule for the case will be. And so it is often the parties that are driving at least the proposed schedule, and the court can decide if they think there's something unreasonable being proposed in terms of discovery, but that is, there is, under the existing rules, an opportunity for the parties to propose a more limited discovery schedule or no discovery at all, or for the court to decide that what they're proposing is not necessary for them to determine the issues in that proceeding.
Yeah, in my experience is that, that is true, but it just kind of it's always a problem in the court, especially if you have, both parties have lawyers, who are experienced. It's just kind of back and forth. The schedule is more about how long it will take to complete the discovery, rather than having limits. And in my experience, it's been hard to get the court to step in and say, no, you can't do that deposition, or you can't do that other round of interrogatories. And yeah, what I've seen, what I'm saying is build into the statute, that there is a limit, you build in the limits in, and then there's exceptions to it. So it's kind of shifts it around a little bit. Like, this is the maximum amount of discovery you could get, unless you could show some hardship or some, need for it, to flip it. Because I remember when they wrote that rule, the intention, I think, was good. And I thought that it would be used. In fact, it was in the early years of the environmental court that I pointed to that. I was in some complex litigation where it was like, hey, we limit this, because I was representing citizens who were getting crushed. And the court was like, no, you have, the rules allow for this, and you still have time before trial. So keep going. And, so I think it's about practice versus how those words have been implemented in practice.
Well, and we have heard from Judge Zone that, and we also, I think, have seen very recently some pushback with the environmental division judges, not agreeing to the parties, wanting, a lengthy discovery period. So I think, that the court is being very responsive in that regard. And we have heard that, I think it was Judge Walsh, testified, look, if you show up at my court and you ask for a hearing, I'll give you a hearing in 30 days. And I have had that experience. And what people are concerned about is when you can't get the agreement between both sides, and one side wants to drag it out or have more time to prepare. The question is, can the administrative setting, confine the timeframes and the amount of discovery more effectively or differently than the court?
Right, I think so.
Ed?
I think the answer is yes. The former environmental board can make a lot of use of Act 250 Rule 14 regarding pre-hearing conferences. And it might be worth digging out of the files some of the pre-hearing conference reports. The pre-hearings were done either by the chair of the board or a designated member of the board. And there were cases, I remember the Pelican Ski Resort had a massive case involving black bear habitat, multiple parties. And the pre-hearing conference report were very diligent in establishing timeframes by which exhibits would be pre-filed. They didn't require depositions, but there would be certainly summaries of what expert witnesses testified to. So there is a lot of, I thought, success in Rule 14. District commissions used to make much more use of pre-hearing conferences than they do these days. So that would be my suggestion, see what, some of those environmental boards, pre-hearing conference report did as a roadmaps.
Annette?
At a previous meeting, one of the attorneys talked about what happens in court these days with so much motion practice and discovery. My impression was the implication was abuse of discovery. I've certainly seen discovery abused horribly at the PUC. And the first case I ever saw where the attorney for the company served discovery on this poor couple, they each got 280 discovery questions, and there were no limits on it. My impression is that the environmental board didn't use discovery much, and I also have the impression that motion practice was limited. And so, as Ed just described, you'd go into a pre-hearing conference, you'd have, for experts, you'd have pre-filed testimony, you'd probably have some direct testimony, and I think that moving appeals to the LURB may present an opportunity to get away from all of the court process that seems to be dragging things out. Timeframes I'm not a fan of. The fact is that there is due process, and sometimes when you get into these cases where they take time, but I think that the ability for both sides, either side, to run out the clock, delay, wear people down. I've seen it happen, and I think that that's something that this process ought to really be looking at, trying to make it more accessible and efficient, and if I may say, not be a gravy train for lawyers. And no disrespect to lawyers. Some of my best friends are lawyers, but a system that's built to support expensive lawyers. And by the way, it's very, very hard to find a lawyer who will represent citizens these days. It's a very slim pool, and good luck with that. And so the process, whatever is in place, needs to be as accessible to the public, regardless of whether or not they have a lawyer. And once you start getting into discovery, teaching people how to write discovery questions or how to engage in it, it's just not intuitive for people. Nobody understands it. They come up with questions that are good for cross-examination, but not discovery. I understand that there are relevant places to do discovery, especially when you're dealing with technical experts. But for a lot of these cases that we're talking about in terms of the types of laws and land use laws that we're dealing with, I don't know how necessary it is. Thanks.
Thank you, Annette. So I wanted to be sure that we also covered Jim Dumont's points. I think he made some really good arguments about his concerns about on the record review. But one of the things I wanted to draw your attention to is that he took Rule 5 in the environmental court rules and regarding how appeals are filed. And he has a suggestion to at least shave off some time off of the initial paperwork when docketing an appeal. And his idea is that the notice of appeal and the statement of questions, which is what the appellant writes in terms of defining the questions and the scope of what they want the appellate court to look at, that those should be filed together. And I think that although it's a small little time sliver, it certainly helps. And it's more than just the 14 days, because honestly, what happens often people, it's one of those non-hard deadlines where they're not gonna just dismiss your appeal probably if you miss the deadline. And especially a pro se person may not know that they have to file things, by certain deadlines yet, because it's the very beginning of the case. So that to me sounds like a really great idea. Often when you file a notice of appeal, depending on court and the venue, sometimes you have to specify in that notice of appeal right off the bat. So I think that it's a really good idea. Does anyone have any concerns about that the 30-day appeal period is not enough time to formulate your issues when you file that notice? Thomas?
This is Thomas Weiss. I read that the other day, must have been Sunday, yesterday. Anyway, and I have a lot of concerns. I don't understand the context of Rule 5. So, it's not clear to me how does a non-appellant become a party to an appeal without filing a cross appeal, because his Rule 5 is limited to cross appeals and additional appeals, if I read it correctly, that he's referring to. And what is the effect of the changes on the amount of time a non-appellant party has to find an attorney and prepare a cross appeal? It appears that the appellant has 30 days now to find an attorney and prepare an appeal, and then an additional 21 days to submit a list of questions. Non-appellant parties would be given only 14 days to appeal and submit a list of questions, find an attorney because they might not have one. And so it seems to be biased against non-appellant parties. So maybe someone who understands this rule a little better might comment on that, but that's my concern reading the two changes on the face of the changes as they were presented in his letter.
So there's a notice of the appeal, and then any other person who wants to enter an appearance has to do that within 21 days after that. And then I believe the statement of questions is also due within 1 days after the filing of the notice of appeals. And then there's if a timely notice of appeal is filed, any other person entitled to appeal may file a notice of appeal within 14 days of the date on which the statement of questions is required to be filed. So I guess it's 14 days after the 21-day deadline. So you have some more time. So notice of appeal, then you have 21 days if you're not the original appellant to decide whether you're appearing. And then you have additional time to file a cross appeal.
But how do those times compare with what the appellant has in order to
I see, right? They have
to
30 days.
decide from the end of the case, the appellant has a certain number of days to appeal. And then.
Well,
that's
anybody-
certain other
anybody
number
could
of days.
appeal.
So anyway, my concern is, I don't need an answer right now. But I think this is a concern that it appears to me that it's shortening the time available to non-appellant parties to be able to respond to the appeal, hire an attorney, develop their list of questions in a much shorter time period than the appellant has. And that's my concern. And research it before making a decision on this. That's really what I'm suggesting.
Follow-up question. Sure, because this is exactly what happened in our case. So the appellant, the ample amount of time that they were given, or not ample, it's the wrong word, they went to the limit of the time that they were allowed. There were cross appellant, I don't know what they were called, they were added on. Other people wanted to join the appeal and they joined it afterwards. And so they had a certain amount of time, I think, to join in. But they, I think, could have, and this is what I think you were about to say, they could have appealed themselves.
Right.
And they could have become an appellant on their own. They didn't, they chose to join an existing case that was already in motion. And so there was time limits on the time you could do that. So I don't know if it was really against them. They made a choice of how they wanted to enter into the case and, you know, and time marched on. So I don't know how that is working against them if they were joining something that was already in motion.
Yeah, I mean, it's a level playing field in terms of and I understand obviously applicants have had more time to develop their project. But you're going through the permitting process, you get a decision. Municipal, you've gone through these zoning hearings and time has expired, has been going along. At the point at which a decision is made, everybody has 30 days to appeal that decision. And so that asking you to say, why are you appealing that decision at that moment in time? You have already been through the process at the zoning board or in Act 250, whatever it may be. So I hear what you're saying, and I many times was the lawyer that was found at, the night before the appeal period was running, and I had to put in a notice of appeal and figure out later what are the issues that you want to appeal, frankly. But yes, people will have to move quickly, but we're trying to shorten a process that has become and identified as problematic. And so if timing is an issue, we're trying to figure out where can we shorten those time wasters where we're waiting for things to happen in the litigation process.
My recollection is that with the old environmental board, definitely the water resources board, you had to follow your issues with the appeal. So, I mean, we did it before, if I'm right. I'm definitely right, I think, about the water resources board. Memory's more fuzzier. So I don't think it's a burden. And I think what you're talking about is you can intervene, so it's not even cross appeal. So under the rules of civil procedure, once a case is ongoing, then anyone can like intervene. And then to intervene, you have to show you have the particularized interest, so it kind of loops back around to that. And there's no time frame to intervene, like it's just a fairness issue. Because I recently dealt with this issue. Like what's the time frame for intervention? And there isn't any specific time frame right now to intervene. Now, most people don't. It's not really an issue. People usually intervene before the first pre-hearing conference is occurring.
By intervene, do you mean join the case?
Yeah, join the case, yeah, but not cross appeal. I think what Thomas was talking about, like the cross appeal.
Well, I don't understand the jargon.
So cross appeal is if you look at the appeal and you're like, well, I wasn't going to appeal in the first 30 days, but now that someone else has appealed, I think I have issues that are different. So I want to also now appeal and put my issues. So then I also get the file statement of questions and put issues before the tribunal. Intervention is you don't get to do that. Intervention is you get to join the case, as you're saying, and then you're basically weighing in on the issues that everyone else has put on the table, right? Like what VNRC does it's because, this is an issue that's been put on the table that if the court decides one way or the other, it could really affect kind of how the environment is protected. So we don't want to put any new issues on the table. We want to be able to at least weigh in on those issues because we could be affected by the decision. But it's just as hard to intervene as it is to cross appeal. Cross appeal just strings it out longer because you're adding issues to the case, so it makes it.
Yeah, the last cross appeal that I did when I was a practicing attorney was the other side appealed my client's permit. My client got some conditions that are fine, you could live with them, weren't ideal for him. But once the case got taken up to the environmental division, it was like, okay, we're gonna go ask for what you originally wanted, even though you didn't get it. we're gonna have to litigate it and spend a bunch of money anyway to send my kid to college. Well, we might as well throw this into the mix. So, cross appeals sometimes just happen because you didn't get the whole enchilada and you want, another try at convincing the court that that condition shouldn't be imposed because it's not necessary. What would we like to talk about now? Because we're 5 minutes out from when we were looking to wrap up and discuss a little bit about where we are and what we would like to do at this point for the next phase, which is really go to have conversations at the board conceptually so that we can share the information from the stakeholder meetings and be able to assimilate all of the information that we've gotten so that the board can sit down and talk conceptually about how do we want to proceed now. Because there are a number of things that we need to define, depending on what parts of this conversation are of interest to the board, what other information that they need in order to really analyze and make sense of all of these really robust conversations. What data, what feedback, what specific issues that we would like to have more conversation on and more feedback. And so I'm contemplating a little bit of a recess for the group so that we can then sit down as a board and conceptualize where we're at and how we want to proceed for the remainder of the study. I fully intend on ensuring that voices continue to be heard, because I think we're at a moment where, okay, we have some really good ideas now out on the table, but I want direction from the board about how do you want to proceed, what information, what concepts are of most interest to you. So please raise your hands. Go ahead, Thomas.
I'd actually like to go back to point 5, which is other things to expedite.
Oh, sure.
I was involved with one case where there was appeal, cross appeal, went to court, and the judge sent us out to mediation. And didn't go to trial, came back, judge signed the mediation agreement, turned it into a court order. Then there were problems with the court order, the applicant not following the court order. We went back to court, the judge said, of course, I can enforce my court order. And things went smoothly from there. But it was the mediation part. If the mediation, there was back in 2001 to 2003, a mediation pilot project. I haven't been able to find out the reports on that, how it went. I saw a draft of the first report, but it seemed to be going okay in some cases, not okay in the other. I don't know whether you found that final report. I certainly didn't, in our big board records.
No,
Or
not-
environmental board records,
Yeah.
actually.
no, I haven't found that specific one that you're talking.
Because I was thinking that would mediation be a way, in this case, the environmental board hired a mediator and made the mediator available on a limited basis to a certain number of cases distributed around states, 8 or 10 or 12 or something. So I didn't know if that might be a possibility for using that.
Well, I think that's a double-edged sword.
Or is that time like the hearing officer adds time?
Warren,
I'm glad you brought it up because it was something I was thinking about earlier, right? We saw that most cases at the environmental court settle. My recollection, I don't know if the court still does, is that they require you to go and try and mediate the case, but I don't know how. So I guess the question is, does the LERB have a vision for encouraging settlement of cases before you hear them, like court does?
It's something that, John, did you put in there, David? When, I think David second,
Having the second
yeah,
picture of
the
like,
section, second picture, right? You know, mediation is, I think it's a double-edged sword. I think many people love it, but it has to be for the right case. My experience in the civil division is, often it's required. But, I have seen in the environmental division, many times when people were not interested or didn't have funds, even a state agency not having any monies for mediation, the judges did not require it. So, and I think that it can be a big time waster. This is just my own personal opinion from my experience with it. It's gotta be for the right case. Now, having said that, I can't tell you how many cases that I was like, I'll bet the farm this isn't gonna settle. And in fact, the mediation process was actually able to deliver a settlement, which, you know, many people, including myself, would have, you know, bet against. So I think if it's done right, it can be very effective, but it is also very expensive. Mediators, I mean, more than one party pays, and, you know, hourly rates are $450 now. And even that half rate, it's extremely expensive. So unless we had some kind of ALJ, hearing officer person who could help facilitate that, that would be a staff person. I think the expense is going to be challenging. But, and I think when I saw that as part of the mix, I thought it was a great idea. I think you do need a firewall in that regard, because you can't, you know, function as a mediator as well as a fact finder and decider of the case. And I think that, you know, that would be normal to isolate that person and keep them in that specific role. Annette?
Yeah, the PUC did have a pilot mediation and facilitation project, and you could get a report from them on how many parties chose to engage in it, and they the table. My own experience with mediation is that it can be pretty intense, especially for citizens who are, I mean, I've been surprised at the pressure put on people. Mediation is confidential, so I am not to know what goes on, but I will say to people, sleep on it. And then I find out that they're told at the end of the day that if you don't accept this right now, then you're going to get nothing. And I've been disturbed by the amount of pressure that can be put on people to settle. And so I like facilitated processes, stakeholder processes, more of an upfront, people work together. I have heard of extensive mediation that has been a failure. I've heard of some that succeeded, but I feel
Thank you, Annette. I think we got the majority of what you're saying. Yeah, John?
The only thing I would add is that I do think that they're like, so like what Annette was talking about is a complex case, right? To try to settle, and yes, it's a complex case, so it's gonna be complicated, and it could be expensive. $450 an hour versus like a couple of full days of mediation time does add up. But I think like with looking at the appeals docket for zoning cases, I mean, I think a skilled hearing officer could, without going to mediation, and without, one of the benefits of not being in court is it creates a little bit more of a relax, not as, you know, people in court, it's pretty intense, like, you know. And I think with a hearing officer, if it's like a setback issue or some smaller zoning issues, like where the driveway is gonna go, could say, hey, is there an opportunity? And we'll set a schedule and we'll work through these issues, but is there a way to work this out, that cases could end up settling in that way, especially in the zoning context, maybe even smaller, Action 50 cases. I think, if, in an A&R process that had a hearing officer, similarly, people appeal a permit and they realize just in a conflict with the hearing officer, like, oh, wow, I can't really win this, this is, and things can resolve just through that process without having to go to formal mediation, And it would be interesting to know out of all the environmental court cases, like how it comes to that, how many are through mediation or how many are just through the parties, their lawyers, like getting in the process, seeing the expense and all that, and just without a mediator finding a settlement.
Yeah. No, I'm a huge advocate for mediation, but often and it can be the off ramp. It can also be timely process. No, great information.
Under the current Act 250 rules and more, the way that the question was framed originally made me think of this, but there's a provision about, in the normal course of their duties, district commissions shall promote expeditious, informal, and non-adversarial resolution of issues, and encourage participants to settle differences in any Act 250 proceeding. So you could have something similar in board rules that the board is hearing, administrative appeals. And the judges do that when you show up at court too, and they say, like, well, if you don't work this out, you might not like what I come up with, and get some nudges in that respect, so.
All right.
Thank you for the discussion, everybody.
Great information. We very much appreciate your coming to all of our meetings, Thomas. Really, so nice to have public members to come and talk with us.
You're welcome.
Just me. So. So I'm going to open up the floor for any public comment, and then is there anybody who wants to say anything, or any of our stakeholders that want to say anything else for today's session? Yeah.
So what are next steps?
Okay. So the next steps are, I'm going to sit down and assimilate all of the information that we have so that I can tell a story. Right now, we have lots of, charts and information. And what I'd like to do is write that into a story so that we can pull all of that information together and look at it in a comprehensive way. To see where we are at, what process that we've come through, what the issues are, what we've heard about on the different issues, so that I can have the board have the information in a comprehensive summary, so that we can have a discussion as a board about what information that we looked at and where we want to go with this in terms of the focus of the continuing process. I'd like a new phase now to be able to check in with the board, have them talk about concepts, and map out where we're going to the extent possible by expressing preferences or desires for more information about specific concepts or structures of board models. At the same time, we have not forgotten about the court process and making sure that we effectively collect all of the information that we can provide in terms of any ideas in the status quo situation to speed things up, or the MSK model. Would it benefit the environmental division and our land use process to have enhanced jurisdiction of the court? Because often these cases involve issues outside just the permits. There may be boundary disputes and those kinds of issues going on as well. So what I'd like to do is have an opportunity to sit down with the board, go through all of the information and materials, and get a weather report on the map, the roadmap of where we want to go now, so that I can then delve into further data that the board may want to see in specific, issues about who, what about the cases and why are they settling? I mean, there may be more of a deep dive that we need to collect information so that we can step back and say, all right, this is a big issue, but it's an issue that's affecting a small number of cases. Because those facts will help us to analyze the situation and be able to come to options that ultimately we can bring back. And then I'm not promising you folks a fully baked cake, but to understand what the ingredients are that the board wants to pursue and things are promising for further study, and to come back to the stakeholders with very focused issues, components, concepts of these different approaches. I will tell you, there's no agenda here. We're trying to fulfill this statutory mandate so that we can, as a board, then with all of our stakeholder input, really sit down and make some choices and recommendations. As Representative Holly suggested to us, we want to be as useful to the legislature as we can, because they clearly want to look at this, they want it tested and figured out, and they would like us to make a recommendation. And all 5 of the board members are very diligent in their desires to make sure that we involve all of our stakeholders and make sure that we are getting accurate information about what people's experiences have been, because we're trying to solve some problems, and there's more than one way to do it. And I think there are compelling arguments on the ultimate issue of court versus board on both sides. And it's a really challenging issue that's been talked about for a long time. So I will leave it there. And again, in the interim, anyone who wants to contact me, has information, ideas, questions, are not quite understanding everything, please feel free to reach out to me.
Are you gonna look back to this group with the recommendations and we'll have an opportunity to comment on them? Or how's that feedback loop gonna work?
Yeah, so what I want to do is get information from the board and then come back. I would like to come back to the stakeholders. And what I'm envisioning is something a little easier than the physical meeting that we have, because if we could just do Teams meetings for these more focused, it might be an hour and a half, not a 3-hour meeting. But the amount of resources and human resources that this kind of meeting consumes, that we can do it a lot more expeditiously. If people are okay with just doing it online on Teams. And that way we can get some shorter meetings that are not such a time commitment for people, where we can really focus on some issues of importance that we want clarification on and opinions about. So I see that for the month of July. I want to bring this information to the board, have a conversation with the board, and then I would say within 3 or 4 weeks, then I would like to have that further meeting opportunity with stakeholders. And in the meantime, I am beginning to write up the report, but it's just, this is the charge. This is the law, where we held this kind of process so far going through the stakeholder situation. Just to get all of that roadmap information, the typical stuff. Nobody's writing a report about anything, and I want to be very clear. It's about a board process. I happen to be the most experienced in this arena, but I have no agenda, no preconceived notions, and these are really tough issues that have to be talked about at length. So we appreciate everyone's time tremendously. Thank you very much. And please feel free to email me at any point, but I think we just need a couple weeks for me to be able to collate all the information, and have the board sit down and look at it and address how we're moving forward at the next phase. No one's going to be writing recommendations without further conversations.
Thank you.
Sure. Okay,
Sounds good.
great. Well, thank you all very much and try to get to your cars quickly. Boy, it's brutal out there
If you
today.
need IT assistance, you know who to call.
Sorry about the
Hey, you got it.
tech challenge today.
Summer, yeah.
I'll be in touch.
She's really gonna pick up her kids. Okay.
Emails on you.
Yeah.
That's easier.
No, it's funny, I looked over at your building the other day, there's Peter hanging out on that.
Oh, and then.
You're welcome.
Oh, they haven't up in the section.
Oh, on the.
Stop it, Lake Champagne on the way out. What is some? Like a little lady.
We should get maybe you have to take.
So you were your,
Yes, yeah,
Yeah.
it was great.
yeah, it's really great. Yeah. Such a good thing. That was actually, I know it was a good ordeal. Years, but. Working with the, well, not, but it's easier than that one.